I just wanted to say a thank you. So Sarah, you can go to the second slide. This presentation originally was created for the Society of Trust and Estates Practitioners, which is, you get a designation from that organization, and they help train professionals in various disciplines on these issues. But myself and Jennifer Reynolds from Fresh Legal in Ottawa prepared the presentation for that organization. Then we wrote an article on it. So some of what I'm talking about today is what her and I collaborated on, and I just wanted to give her a thank you and a shout out for her assistance. I personally don't do family law. I do the estates and the will side, but I do have to have knowledge of family law and how it impacts to better advise my clients. All right, so Sarah, you can go to the third slide. So firstly, how do family law and estate and wills law impact each other? So the first thing is, if you're married or if you're living with someone and not married, there's a difference on how that impacts things. There's legal obligations that arise from both of those relationships. Also, there have been some recent changes to law or change to the case law where even couples who have a long-term relationship but didn't live together were found to have support obligations to each other. So being clear with your lawyer when you're getting your documents completed about what your actual legal relationship is and what the actual relationship looks like as well in terms of how you support each other is very important. So property division is one of the things that arises out of a relationship breakdown. And a relationship ends in one of two ways. One of the members of the couple dies, or you split up or separate. So for married couples, there's very specific rights about property. So this is legally married only. There's the net family property equalization, which, just a very short summary is the deal is that you're supposed to both share in the wealth that you created during your marriage. So what you owned on the marriage and what you owned on the end of the marriage, that gets divided and equalized between the two parties. That's only for married couples. Couples who are living together don't have the same rights, although they do have some rights with respect to property. Obviously, if you are, building a home together, sharing a home together, there's certain rights that you may have. Some of them might be rights with respect to support, and some of them might be rights with respect to property, but they're just not as clearly delineated as they are for married couples. The other issue with married couples is there are specific rights in the home that you share as a couple. If you are legally married, the way that property gets treated in the equalization process is slightly different. But spouses who live together, depending on the ownership or whether one of them is the owner or not, they have rights in the property that they reside with together as well. So for example, if your relationship ends by one of the members of the couple dying, if that was the home that both of you shared during the relationship as your family home, even if the will says that the surviving spouse isn't going to be the owner of that property on death, that spouse still needs to consent to certain dealings with the matrimonial home, and they may have additional rights that override some of the rights in the will. Also, in some cases, people might not own the property that they're living in, but one of the members of the couple may own it with a family member. If it's, sometimes for financial reasons, for mortgage approval reasons, we're seeing that more and more where, a very young couple just starting out, they can't get a mortgage on their own. So sometimes they'll do the mortgage with one of the parents, or sometimes it will be one of the members of the couple with the parent. So say, man and woman living together, and their parent, one of their parents is on title, and say only the wife is on title with her parent. The husband is not on title. If one of them was to die and they owned the property jointly with their parents, so joint with right of survivorship, that right of survivorship is terminated on death to make sure that the spouse will still have some ability to access, the equity in the home. That's probably it. I don't need to go into too many technical details, but there's just those special things that happen with matrimonial homes on death that can, things won't necessarily go the way that you planned. There also are rights in the matrimonial home to live in the home for a period of time. after death. So again, in most cases, people are going to want to make sure that their spouse is taken care of and doesn't have to move immediately after their death. But those are things that you need to be aware of when you're thinking about what would happen in the event that one of you passed away. The next thing is child support and spousal support. So obviously, if you have a child who's a minor, you have a legal obligation to support them. But child support can come up in different ways. So there's the child in place of a parent situation. So you're a step parent and you are, contributing to the financially, to assist your stepchild, financially and emotionally. There's no, again, bright line test, but there are instances where step parents did have child support obligations, and those child support obligations could be found after death. So that's something to consider, when you're making a plan to make sure that all of the children that you are caring for are supported. As well as spousal support. So I talked earlier about couples who didn't actually reside together, but support each other in many ways. There being a support obligation found there. So that is another thing to consider. And additionally, very recently, adult children with disabilities who are unable to live independently. There may be support obligations for those adult children that extend well beyond them turning 18 or 22 or whatnot. So, parents need to consider that as well, and potentially step parents of adult children with disabilities. And generally speaking, even if an adult child doesn't have a disability, the general rule is that there is an obligation to support them until they are at least finished one undergraduate degree, or if they're going to trade school or something like that. So it extends beyond just the age of 18 isn't the magical age where support ends. Marriage contracts and cohabitation agreements. I strongly recommend these to most of my clients, particularly if you're in a second relationship in your adulthood. That is my own personal situation. If you've gone through any kind of separation at all, it can get quite complicated, and a marriage contract or a cohabitation agreement can set out what would happen in the event that you or your partner split up, and also if one of you passes away. In some cases, it might be appropriate just to deal with what happens if you die, so that you can override some of the default parts of the legislation and make that agreement when you are making your will, to make sure that all of the pieces work together and that there's no there's no confusion. Everybody's clear. There's been full disclosure about assets. Oh, did I just get muted? I think I'm okay. So those two things should work together. A marriage contract is you're getting married and you settle all the different things. A cohabitation agreement is the same thing, except you are not getting married, you're living together. And the cohabitation agreement can extend, and apply when you're married if you do decide to marry at a later date. People who really need those agreements in any instance are, so blended families for sure. Things can get quite complicated with blended families, whether the children are adults or not. You need to make sure that you are thinking about how to deal with both parts of your family and make sure that your children are taken care of and that your spouse is taken care of. And a simple situation for blended families, it doesn't exist. If you co-own a business or a family property, like a cottage or something with other members of your family, or if you own a business, either with family members or with a business partner, those things can get kind of complicated. So cohabitation agreements and marriage contracts, in conjunction with your will planning, can certainly address those particular situations. The other thing is that if you're a parent and you have adult children and you're looking to, financially assist your child to buy a home, or I do have a lot of clients that have a considerable amount of wealth, so they like to share it with their children, as much as they're able to. In those cases, really a cohabitation agreement or marriage contract is a good idea to make sure that the gift that's being given to the child does not have to be equalized in the event that there is a separation or divorce, or if there's equalization that happens because of their child's death. And usually we document those gifts as well as they happen, to do a deed of gift is what it's called, to make sure that those gifts are completely separate. They aren't joint property in the marriage, and then parents can protect the gift that they're giving. And this isn't just for wealthy parents. I mean, I do have some that give, significant gifts every year. But if you are, a middle class parent and you're helping your child out by giving them $20,000 as a down payment on their first home, I mean, that's a lot of money for you, and you want to make sure that it's somehow protected, or that you're documenting it as a loan or something like that, so that you don't lose, or your child doesn't lose that gift that you've given in the event of an equalization. So guardians for minor children is one of the big ones that parents of minors have the toughest thing deciding. And, we usually walk through that with them and figure out what the best thing is. Some things to think about are, if you are appointing, if you have minor children, you want to appoint your sister as the guardian for your children, and your sister is married. Do you want your sister and your sister's spouse to be the guardians, or just your sister? The reason being is that if your sister and her spouse happen to separate, while it will still be a little bit ugly, if your sibling is the only one that's the guardian, it can make things a little bit cleaner. Conversely, I have some clients where they have either multiple children or children with special needs, and they don't feel that a single parent will be able to parent their children. They feel like there needs to be a couple. So I have had some clients say, I want it to be, my brother and my sister-in-law, but only if they're still a couple. If they aren't, then it would be, my sister and my brother-in-law, or something like that. So those are just things that you need to consider is, basically you have to consider kind of worst case scenarios in a lot of instances, and will it still work for your specific situation? And also, what are the family law implications if, the couple that you're appointing as guardians were to split up? Sorry, just looking at my notes here. Sorry, my assistant is buzzing me. The other thing is that, sometimes you just can't decide. You just can't decide who should be the guardians of your children. So in those instances, you may want to appoint joint guardians. So, if you have two siblings, those siblings could be joint guardians. And you'll need to have a conversation with them about what that might actually look like. Do they live near each other? Practically speaking, is it going to work? And then, there are kind of family law considerations there. It would be basically like, a couple that had split up and had joint custody of their children. It would be a similar situation if there was joint custody of your children. And just making sure that the people that you're appointing jointly will be able to work together and will be able to come up with some kind of an agreement that's in the best interest of the children. It also can be a very touchy subject, guardianship with extended family members. Grandparents in particular, sometimes aunts and uncles. You may not want to talk about it with your family. I do recommend talking about it and letting them know why you're making the choices that you're making. But if you just feel like you can't bring it up, if it's just going to cause a family fight that's not worth it, you may want to leave a message, a note explaining why you chose who you chose. That letter or memo or whatever you want to call it, it may be helpful for grandparents understanding why they weren't appointed. It also may be helpful in the event that someone challenges the choice that you've made in court. It's an indication of your wishes. And, it may also, you can provide some instructions in there about, I've appointed, my sister and my brother-in-law as the guardians, but I still want my parents to have reasonable access, and I want, the other grandparents to have reasonable access. We want to make sure that they have relationships with all of their extended family, that kind of thing. So you can go on to the next slide, Sarah. All right, so in addition to actually choosing the guardians, you need to just make sure that you've got adequate provisions for the guardians. So thinking again, practically, how is this going to change my guardians' lives? I have, if I have 3 children and they have 2 children, they probably need a bigger house. They probably need a bigger vehicle. If they have 5 children, maybe one of the members of the couple may need to stop working and stay home to raise the children if they're very young, or they may need to hire in-home care, those kinds of things. Is there going to be money to fund that, and how much discretion do you want to be given, to make sure that the guardians have sufficient funds to do the day-to-day raising of the children? There's most of the time there's always gonna be enough money for education or whatnot. But, the day-to-day things and practically where is everybody gonna live and how are they gonna be driven around, you need to think about that and make sure that it's clear that you want that to be provided. The All Families Are Equal Act, it's kind of complicated. The gist of it is that, parents and children, families can happen in various ways. So the All Families Are Equal Act in part recognizes some of those things. It allows children to have more than two parents in some instances, and it really just allows intention to follow legal parentage. So reproductive technologies and things like that is just recognizing those kinds of relationships. But where it can get a little bit complicated is that with the changes to the All Families Are Equal Act, there's also now, you can use reproductive technologies to conceive a child after someone's died, and potentially there could be support owing for that child. So do you need to talk to your family members about, if they have reproductive materials stored? Because that might not affect just, the parent of the child. It can affect other family members if you're defining grandchildren or if you're defining nieces and nephews and things like that. So it's a good idea to the extent that, it's not inappropriate to ask, just find out if any of your family members have stored reproductive materials, or when you're talking to your lawyer, just talk about how you want to define your heirs. And in some cases, you may just want to say, your heirs kind of end when, the person that the person that you're related to. So if your child, your heirs ends when your child dies. Like if they have children after they've died, that's not included in the class of heirs in your will. Or you may want it to be if you know that that's something that can happen. It's a little bit technical, it's a little bit complicated, but it's just something to bring up because it's a recent change to the law. And sort of kind of coming with that is DNA kits and surprise relatives. I can't tell you how many people that I know, I have a lot of colleagues, some of them personally, and I have some friends locally who have done the DNA kits online, and there have been surprises in their family tree. Sometimes the parentage is not what they expected. Sometimes there's cousins, things like that. If you don't know anybody that's happened to yet, you will within the next couple of years. This could be its own presentation on its own, but if that ever happens in your family tree or in your own immediate family, you probably need to change your documents at that time. Because depending on the jurisdiction and depending on if you have a will or if you don't have a will, a child could be included or excluded, and either of those may not be what you want. For example, I have one case where a friend of mine found that her father, who she thought was her father, both her parents actually were not the parents she understood them to be. It was a sibling who'd had her at the age of 17, and she was told that was her sister, and so the father was obviously someone different as well. She wants a relationship. She has a relationship with the person who is her biological father now. That person wants her, to inherit equally with his other children. So he's got to change his documents. And then she also needs to consider in her own documents, is he included in her relatives? And then, the original family needs to consider if they need to change things. It can get very messy and ugly, but, depending on what you want, you probably need to change some definitions there because the standard definitions may not apply in those, surprise relative situations. Another big one, we talked about support already. It's something that a lot of people don't know about, dependence relief. So if you have a minor child that you're supporting, you probably have an obligation to support that child. If you have a spouse that you're supporting, you probably have an obligation to support that spouse. But there's other dependents that you may have an obligation to support. And dependence relief is a claim that can be brought against an estate where the deceased was supporting someone and the deceased dies and doesn't adequately provide for them in their will. That can include financial support and non-financial support. So, in these times of COVID, we're seeing a lot of intergenerational living arrangements where people have, moved back to families so that grandparents can assist with childcare during the day or online learning. Those situations are probably creating more of a situation of support than prior. In other instances, grandparents or extended family members could be providing significant caregiving support. So, driving to and from appointments, arranging things for them, getting groceries, those kinds of things. So even those activities could potentially be activities that would be considered to be you're supporting that person. I know in a lot of instances as well, there's usually someone in the family that is being officially or unofficially financially supported by someone. And, that relationship is slightly different than, than a relationship with the other children. And that child may have a claim on the estate for dependent support. So if you're talking to your lawyer, you need to be clear about what your actual relationships are. You may not think that you have an obligation to support someone, but if you are in fact supporting them financially, emotionally, and otherwise, you may have an obligation and your estate could have a dependence relief claim brought against it. The other thing with a dependence relief claim is that if it's successful, it can sometimes kind of implode an entire estate plan. The reason being is that assets that are typically not included in the estate can be recaptured to satisfy the dependence relief claim. So if you have life insurance and you name beneficiaries, that can be recaptured and brought into the jurisdiction of the court to be dealt with to satisfy a dependence relief claim. Also, gifts that were given just prior to death can be brought back in. Even sometimes assets that were jointly owned and things like that where a beneficiary was named, the court has the jurisdiction to recapture those assets. So if you are in fact supporting someone, again, not just financially, in other ways, you need to consider that when you're making your will. So the last sort of big topic is the impact of cohabitation, marriage, separation, divorce on your wills and powers of attorney. So in Ontario right now, when you marry, your will is revoked by marriage. That law may change in the near future. There's a discussion that's going to change, but for now, that's the law of Ontario. If you marry, your will is revoked by marriage. So there's a lot of people out there whose will was revoked by marriage and they don't know it. So that's one of the big things. Your powers of attorney are not revoked by marriage. They're not revoked by divorce either. And they don't powers of attorney don't change regardless of what your personal relationship situation is. So, for example, you may have done powers of attorney when you were young and single, and then now you're in a 15-year relationship, a cohabitation relationship with someone, and you haven't named them as your attorney for property. The rights that they have would come second to whoever you'd named in your power of attorney. If you became ill and making decisions, they would still have some consultation rights, but the person that you've named in your power of attorney documents is the first person who would have a right to make decisions about your care and decisions about your finances. Obviously, that can be a problem whenever you're in a long-term relationship and your finances are commingled. The other thing is that, so divorce doesn't revoke your will. If you are legally divorced, your former spouse it's read as if they've died before you. So effectively, they wouldn't inherit anything, but that's only if you're legally divorced. The other thing is that if you're legally divorced for decades and you don't change your will, or you change your will after divorce and you still leave your former spouse in there, which some of my clients do, sometimes there's very good splits, and sometimes my client will say, well, if I die and my children die, what I have effectively is built upon what I had in my relationship. So I want my former spouse, to inherit if the three of us die. So that would still be valid, but you need to just make sure about what your wishes are. Even in my own instance, when I separated, I didn't change my documents for a while because I knew everything was really just going to go to my children ultimately through my former spouse. And then after a few months, I thought, well, okay, I don't really want him to make decisions about my healthcare. And then I have a business that needs to be addressed. Like, so even I do this for a living. I didn't really think about the need to change things as soon as I separated. And I should have. If you are separated, it doesn't change your will. So your will, if you named your spouse as the executor and they get everything, if you're separated and not legally divorced, that doesn't really change anything unless you have a separation agreement that addresses that. So there's usually a long time in between separation and actually coming to an agreement. And that limbo period, it can create a problem. Again, that doesn't impact on your powers of attorney at all. So aside from dying, again, if you're entering into a new relationship, if you're married, your will's revoked by marriage. But if you start living with someone, it doesn't change anything, but your legal obligations to them change. So we've already gone over all of the rights that people that you support may have if you die. So it's really a good idea when you enter into new relationships that you take a look at what you've done in your documents and make sure that there's no need to change anything or consider a cohabitation agreement, just to address what would happen. The other thing, there was one more thing I wanted to address about that. Cohabitation, marriage, separation, divorce. I just had a thought, and it was I had to continue what was I saying, and I forgot about it. Divorce. I apologize here. So the divorce. If you have a divorce order, it does impact on your will. Obviously, your spouse is right as if they've died before you. The change in the legislation that is proposed is suggesting that if you're separated for 3 years, that the same would apply. So if you die and you've been separated for 5 years, the change in the law that's proposed is that your separated spouse would be the same effect as if you're legally divorced. That can obviously get a little bit messy. When was the date of separation? Are you actually separated? Are you still supporting each other after you've separated? Because often that's the case. So again, it's not just waiting until a divorce. It's really, you need to think about any change in your life relationships. You need to think about what you need to do to change your documents, because your legal obligations can change. They can increase, they can decrease, they can stay the same, or they can get just extremely confused and convoluted, and it would just increase the cost of administering your estate. So it's just a good idea, at all steps of your life, and even the lives of others around you, to think about, do you need to change your documents? Do they need to change theirs? Do they need to change their plans? Who has legal obligations to who? And, you want to just keep things as simple and uncomplicated as possible. Although, as you probably have guessed through my conversation in the past 25 minutes or so, it can get a little bit complicated. So Sarah, you can just go to the last slide. Effectively my presentation portion is finished now. We can now open up for questions, and I think we can stop recording now. Did you